Every cop show you've ever watched is lying to you. Those famous words, "You have the right to remain silent," didn't exist until 1966. And the man who gave you that right? A violent criminal who confessed to everything. March 1963. Phoenix, Arizona. An 18-year-old woman is walking home from work when a car pulls up beside her. What happens next will eventually reach the highest court in America. But here's what nobody tells you about this case. The man who took her, Ernesto Miranda, confessed within 2 hours of his arrest. He signed a written statement. He identified the victim. By every measure, the case was solved. So why did the Supreme Court throw it all out? And why does that decision still protect you today? The answer reveals something disturbing about what American justice actually looked like before this moment. To understand why this case matters, you need to see what interrogation looked like in 1963. There were no rules. Police could hold suspects for days without charges. They could deny access to lawyers. They could lie, threaten, and manipulate until they got what they wanted. And here's where it gets darker. If you're learning something about your own rights right now, drop a like because this gets more disturbing. Confessions obtained through psychological torture were perfectly legal. The courts didn't care how police got their statements. Miranda himself was interrogated for 2 hours straight. No lawyer. No phone call. No one telling him he could stay silent. He didn't know he had any rights at all. Because technically, at that moment, those rights didn't exist in practice. But let's look at this from a different angle. Miranda's defense attorney was a young public defender named Alvin Moore. He had 17 days to prepare. He'd never argued before the Supreme Court. He was facing experienced prosecutors with endless resources. And yet, he spotted something that would change history. During the trial, Moore asked a simple question. Did anyone tell Miranda he could have a lawyer present? The answer was no. Did anyone tell him he didn't have to speak? No. Moore argued something radical. A confession means nothing if the person confessing doesn't know they can refuse. Think about that for a second. The state was about to execute a man based on words he might never have spoken if he'd understood his options. Miranda lost his first trial. He was sentenced to 20 to 30 years. But that was just the beginning of this story. The case bounced through appeals until it reached the Supreme Court in 1966. And this is where things got explosive. The court wasn't just deciding about one kidnapper in Arizona. They were deciding whether the entire American system of police interrogation was constitutional. Chief Justice Earl Warren, himself a former prosecutor, wrote the majority opinion. But here's what most people don't realize. The decision was 5-4. One vote the other way, and you would have no Miranda rights today. For justices believed the ruling would handcuff police and let criminals walk free. The nation was about to be divided over words that hadn't even been written yet. But that's not even the most controversial part. What happened next shocked the entire legal world. The Supreme Court didn't just overturn Miranda's conviction. They created a script that every police officer in America would have to memorize. If you've made it this far in this story, hit subscribe because the ending changes everything. You have the right to remain silent. Anything you say can be used against you. You have the right to an attorney. If you cannot afford one, one will be provided. These words came directly from the Supreme Court's ruling. For the first time in American history, the court told police exactly what they had to say. Critics called it judicial overreach. Supporters called it basic human dignity. What would you have decided? And then it got worse for both sides. Here's the part nobody expected. Ernesto Miranda, the man whose name would be spoken millions of times by police officers, was retried. Without the confession. And he was convicted anyway. Witness testimony and other evidence proved his involvement. He served 11 years and was paroled in 1972. The system had worked, just not the way anyone predicted. But the story takes one final turn that's almost too ironic to believe. Tell me in the comments if you saw this coming. In 1976, Miranda got into a bar fight in Phoenix. He was stabbed to death at age 34. Police arrested a suspect. And when they took him into custody, they read him his Miranda rights. The very words born from Miranda's case were now being used to protect his killer. And this is the revelation that changes everything about how you see justice. The Miranda warning has now been read over 500 million times. Every single arrest in America includes those words. I want you to remember this part. Before Miranda, up to 30% of confessions were later found to be coerced or false. After Miranda, that number dropped dramatically. Innocent people stopped confessing to crimes they didn't commit. But here's what defenders of the old system got wrong. Police clearance rates didn't collapse. Criminals didn't suddenly escape justice. What changed was simply this. The government had to prove guilt through evidence, not through breaking people down in windowless rooms. Miranda didn't help criminals. It forced police to do better police work. And that's why you have the right to remain silent. So what does Miranda's legacy mean for you today? Every time you hear those words in a police procedural, you're hearing the echo of a 5-4 Supreme Court decision from 1966. A decision made because one inexperienced public defender asked the right question. A violent criminal's case created a protection that shields the innocent. And that's the uncomfortable truth about how rights are born in America. They often come from the worst among us, tested in courtrooms, and applied to everyone. The Miranda warning isn't about helping criminals. It's about ensuring that when the state accuses you of anything, you know exactly where you stand. Because before those 4 sentences existed, you had rights you didn't know about, which meant you had no rights at all. Now you know the real story behind the most famous words in American law. If this changed how you see your rights, subscribe and hit the bell for more legal history that actually matters. What other legal protection do you want to know the origin of? Drop it in the comments. Your rights have a history. And that history deserves to be told.